All right, so we have a bit of an update for you on the Trump so-called hush money trial. You can see the president there. I think this is earlier today, moments ago, walking into the courthouse, doing his usual talking to the cameras. But what we have learned is that the judge has once again let's look at this. Found that he has been in contempt for 4 more additional gag order violations. So we don't know which gag order violations this is. The judge didn't specify, but
there is a legal weapon moving through the court system right now that terrifies Donald Trump more than any indictment ever could, more than any civil judgment, more than any appellate ruling. And here is why it keeps him up at night. This one does not require a jury. This one does not require a months-long trial. This one does not give him the one thing his entire legal strategy depends on.
Donald Trump has been held in contempt for the 10th time at his criminal trial for violating a gag order and fined a further $1,500. Justice Juan Merchan warns he will consider jailing the former US president if he continues to make public comments that interfere with the case. Trump is prohibited from criticising jurors, witnesses and the families of the judge and prosecutors.
The procedural runway, the endless appeals, the legal fog, all of it rendered completely useless because this mechanism cuts through every delay tactic like a hot knife through butter. We are talking about contempt of court, and judges in multiple active proceedings have already used it, already fined him for it, already put the next step in writing. Not another fine, not another slap on the wrist. Custody. A federal judge has already held Donald Trump in contempt for violating a protective order. Hit him with a per-violation fine so steep it would make most people rethink their choices. And then did something far more significant. Put it in writing that jail is on the table if he keeps defying the court. That is not cable news speculation. That is a sitting federal judge creating a permanent record. In another high-stakes showdown, a judge issued a mandatory appearance order after Trump tried to claim absolute immunity.
The Constitution is much more important than jail. It's not even close. I'll do that sacrifice any day.
Jail for former President Trump. The judge in his hush money criminal trial says it's a possibility. Trump was held in contempt for a 10th time on Monday, this time for publicly criticizing the jury.
And here's where it gets real. The judge wrote explicitly that noncompliance could trigger an arrest warrant. Read that again. An arrest warrant for a former president, the same man who spent years claiming he was untouchable. The judge looked at that immunity argument and said, absolutely not, and put the consequences in writing. Then there is Judge Merchan. 10 contempt findings in the hush money case. Not 1, not 2, 10. Each one building on the last. Each one documenting a deliberate, repeated pattern of defiance.
Highly political judge, a totally conflicted judge, who just did something that nobody's ever seen. And the press is not happy, I don't imagine. They just got thrown out of a courthouse. Nobody's ever seen anything quite like it.
And here is the part the late-night comedians are not explaining. Merchant included explicit incarceratory language in those findings, made clear that financial penalties have been tried, documented them as insufficient, and communicated that the next escalation step is no longer about money. It is about custody. Let me be precise about why contempt operates differently from every other accountability mechanism in the legal system. Because this distinction matters more than anything you will hear on cable news. Every other legal tool requires time. Indictments require grand juries. Trials require jury selection and evidence and deliberation. Civil judgments require full litigation and appeals. All of those mechanisms give a defendant the procedural runway that delay strategies are specifically designed to exploit.
I think the case is going very well. We've asked for termination of the case. This case should be terminated. This shouldn't go anywhere. It should be terminated right now. And New York State has to build up its system again. New York State can't let this happen.
The runway that has been Trump's primary survival tool across every single case. Contempt of court does not work that way. Contempt is the court's inherent authority to enforce its own orders. It exists because courts without the power to enforce their directives are not courts at all. They are advisory boards. Their rulings become optional for anyone willing to accept the reputational cost of ignoring them. When a judge finds someone in contempt, that finding does not require a separate trial, does not require a jury, does not require the same procedural protections as criminal prosecutions. Because contempt is not a prosecution, it is the court exercising its fundamental authority to compel compliance with its own orders.
This judge is a very partisan judge, with a person who's very partisan sitting alongside of him, perhaps even much more partisan than he is.
This is what makes contempt so dangerous to Trump's legal strategy. A judge who has documented a deliberate, repeated pattern of contemptuous conduct. Then findings. Explicit incarceratory warnings. Documented insufficiency of financial deterrence. That judge is a single act of defiance away from exercising custody authority. No jury, no lengthy trial, no endless appeals. A finding, a warning, a subsequent violation, and a custody order. That is the procedural sequence the incarceratory language in Merchant's findings is describing. That is the sequence the arrest warrant language in the mandatory appearance orders is pointing toward. Here is what you need to understand about why judges putting jail on the record in writing matters more than verbal warnings in open court. When a judge communicates incarceratory consequences in writing in a formal order in a published opinion, that written communication enters the official court record in the specific form that appellate courts review, that prosecutors cite in subsequent proceedings, that every future judge has access to as documented evidence of an escalating pattern. Verbal warnings are significant. Written incarceratory language is the format the legal system treats as the most authoritative possible communication of consequence. 10 written contempt findings with incarceratory language are not casual warnings that can be dismissed as judicial frustration. They are the permanent written record of a judiciary that has assessed a pattern of defiance and formally communicated that the escalation has one more step available. A step that every subsequent violation makes more imminent rather than more hypothetical. Let me break down why those 10 findings matter so specifically. A single contempt finding can be characterized as an isolated violation, a one-time failure that the defendant can credibly attribute to confusion or inadvertence. 10 findings cannot be characterized that way. 10 findings of violating gag orders protecting witnesses and court staff and family members of judicial personnel across an extended period. That is the specific documented pattern that distinguishes deliberate contemptuous defiance from isolated inadvertent violation. That distinction matters enormously because incarceratory consequences are reserved for exactly that deliberate, repeated defiance pattern. Financial sanctions are the first response tool, the deterrence mechanism supposed to impose a cost sufficient to change behavior. When financial sanctions are documented as insufficient to deter when the violation pattern continues through and after financial penalties, the court's analysis shifts to whether incarceratory consequences are necessary to achieve compliance. 10 contempt findings following financial sanctions that did not stop the violations. That is the specific documented record that shifts the analysis toward the incarceratory tool. The per-violation fine structure deserves specific attention here because it reveals the court's assessment of what level of financial consequence might be sufficient. A per-violation fine is not a one-time penalty. It is a recurring financial consequence attached to each individual act of defiance designed to create a specific financial incentive calculation for each decision about whether to comply or violate. When a judge imposes per-violation fines and explicitly warns that continued violations will trigger incarceratory consequences, the judge is communicating a specific escalation framework. Start with financial deterrence. Document its insufficiency. Move to incarceratory deterrence. A defendant who continues violating court orders through 10 contempt findings and multiple rounds of financial sanctions has specifically and documentably established that financial deterrence is insufficient. That is the specific finding that makes incarceratory warnings operational rather than rhetorical. Now, let me address the mandatory appearance order because this dimension directly attacks Trump's primary avoidance mechanism. The claim that presidential status provides immunity from legal process. The mandatory appearance order with arrest warrant language for noncompliance is a trial court expressing institutional rejection of that immunity claim. A judge who rejects absolute immunity and notes in writing that noncompliance could trigger an arrest warrant has specifically addressed the primary avoidance mechanism and found it legally insufficient. The arrest warrant language in that context is not rhetorical escalation. It is the specific legal consequence that follows from rejecting the immunity claim. If the immunity claim does not excuse compliance, then noncompliance triggers the same consequences that would follow any party's refusal to obey a mandatory appearance order. The consequence for defying a mandatory appearance order is an arrest warrant. The judge noting that in writing is not dramatization. It is the court explaining the specific legal consequence of the specific legal posture Trump has taken. Now, let me address the practical mechanics because this is where things get constitutionally complex and where the fictional videos go completely off the rails with cinematic handcuff scenes. A sitting president has a Secret Service detail with a specific legal obligation to protect the president from physical harm, an obligation that does not automatically yield to a court's custody order. The intersection of federal contempt custody authority and the Secret Service protective mandate is a question that has never been fully resolved because the situation has never arisen before. Legal analysts and former Secret Service officials have discussed the specific protocols that would govern. The likely scenario being negotiated compliance where the president is transported to a specific facility under Secret Service protection rather than transferred to martial custody in the conventional way. Here is what matters. The specific complexity of the mechanics does not eliminate the custody consequence. It affects the operational form the consequence takes rather than whether the contempt power can produce it. A court that has found a sitting president in deliberate repeated contempt and documented the insufficiency of financial deterrence can order custody. The operational form might look different from conventional incarceration, but the legal consequence. A sitting president subject to the court's physical authority through the contempt power. That is the documented endpoint of the escalation trajectory that 10 contempt findings and incarceratory warnings are building toward. The Secret Service and martial jurisdiction question connects to the broader Supreme Court precedent rejecting absolute presidential immunity from legal process. The same principle that says the president is not absolutely immune from subpoenas applies to whether the president is absolutely immune from the custody consequences of a contempt finding. The Supreme Court has never said the president is above the court's contempt power. The court has said the president has some immunity from some legal processes in some contexts, but the specific immunity that would insulate a president from consequences of deliberate repeated violation of court orders protecting witnesses and court personnel, that is not a clearly established constitutional protection that existing immunity jurisprudence supports. The courts are not writing incarceratory language into formal contempt orders as rhetorical gesture. They are communicating the specific consequence that the legal framework available to them supports imposing when the deliberate repeated defiance pattern has been documented with the specificity that 10 findings and documented financial deterrence insufficiency provide. Here is where this fits in the bigger picture. The Meadows cooperation established the inside political account. The lawyer guilty pleas established the inside legal strategy account. The judicial falsity findings established formal court documentation of intentional false statements. The Supreme Court tariff ruling established limits on emergency power overreach. The Bondi perjury accusations established criminal exposure at the Attorney General level. And the contempt findings with incarceratory warnings are the judicial conduct management dimension of the same accountability dynamic. Courts using their inherent authority to address the specific pattern of treating judicial proceedings as political stages rather than legal forums. All of these dimensions are operating simultaneously. Every new social media post that violates gag orders protecting witnesses and court personnel is a potential new contempt violation. Every new hallway camera statement attacking the presiding judge is a potential new finding to add to the documented pattern. Every new claim of absolute immunity that a court rejects in a mandatory appearance context is another rejection of the primary avoidance mechanism in the permanent record. And every new incarceratory warning in writing from a sitting judge is another formal communication that the escalation trajectory has one more step available. So where does this leave us right now? It leaves us with a federal judge having already held Trump in contempt for violating a protective order, a steeper violation fine, an explicit written warning that jail is on the table, documenting that financial deterrence has been deployed and communicated as the first response tool. It leaves us with 10 contempt findings building the specific documented pattern that distinguishes deliberate defiance from inadvertent violation. each finding adding to the predicate that incarceratory warnings require to be legally supportable, each one making the next escalation step more operationally imminent. It leaves us with a mandatory appearance order carrying arrest warrant language for noncompliance. The specific written judicial rejection of the absolute immunity avoidance mechanism in the official record, establishing the court's formal position that the immunity claim does not excuse compliance, and that defiance triggers the same consequences available for any party's refusal to appear as directed. It leaves us with the practical mechanics of contempt custody being operationally complex but legally available. The Secret Service intersection affecting implementation form rather than consequence availability, with Supreme Court immunity rejections providing the doctrinal foundation for contempt authority to reach a sitting president whose defiance has been documented with the specificity the incarceratory predicate requires. Stay tuned,